Thanks for joining us today. My name is Scott Cuthbert. I'm CEO of Safepedia, and we're super excited to be partnering with Conn Maciel Carey this year to do OSHA Quicktakes. So this month, we're talking about the strategies for responding to whistleblower complaints. And I'll turn it over to our guests from Conn Maciel Carey to do a quick introduction, and then we'll dive into the topic. And just for anybody who may not have seen any of the previous quick takes, this is just a quick 20 to 25 minute kind of introduction to the topic, and there will be a long form webinar that Conn Maciel Carey hosts on March 21st. So if you want to dig deeper, then definitely sign up for that. We'll have the links and everything below so that you'll know how to register and show up for that longer form webinar. So with that, I'll turn it over to Lindsay. Did you want to kick things off?
Sure. Hi, everyone. My name is Lindsay DiSalvo, and I'm a partner at Conn Maciel Carey in both the employment practice and our workplace safety practice, which I think is particularly relevant for this webinar, as this is definitely a crossover between our two major practices. We'll cover some issues in the retaliation and whistleblower context, which implicate all sorts of laws that we'll get into in a little bit. So it should be a really interesting topic. And I'll kick it over to Jordan to introduce himself.
Thanks, Lindsay. I'm glad to be part of this webinar. My name is Jordan Schwartz, and I am the only one on this webinar that is actually not an OSHA attorney. I am 100% an employment attorney. I counsel employers and then defend employers on all aspects of the employee-employer relationship. So I'm excited to give my particular expertise and particular bent on how you can defend and avoid whistleblower and retaliation complaints from the employment perspective, while Lindsay and Victoria talk more about the OSHA and general best practices perspective.
Great, thanks, Jordan. Yeah, Victoria, sorry, jump right in.
No, that's fine. Hi, I'm Victoria Voight, and I am one of the newer members of the firm. I'm of counsel. I am both labor and employment and OSHA. My background is in state government. I was the OSHA attorney in North Carolina for 20 plus years, and I also represented the state as an employer before EEOC and other forums. So this is a topic near and dear to my heart. I've dealt with it a long time, and I'm happy to offer any insight I can for other employers out there having to deal with these.
Great, so it sounds like we have everybody pretty well covered today. So let's jump into the first question, and let's talk about why this topic is important now.
Yeah, I think that's a really good question, because I think it's important context for the discussion today, as well as the longer form webinar. We've definitely seen an uptick in whistleblower and retaliation complaints over the past couple of years, particularly, and we've definitely seen that coincide with the pandemic. That's one of the reasons, I think, in our experience, and we've seen an uptick both from an experience perspective and just having more clients that are dealing with whistleblower and retaliation complaints. But also, the statistics put out by the various agencies show that there has definitely been an increase in the number of complaints with a retaliation component or whistleblower complaints. We think there is generally, I think, more knowledge at this point about the various tools available to employees per the pandemic and experiences during the pandemic and information shared during the pandemic. And I think it's also definitely been a focus of the agencies in this administration. We know for sure that OSHA has delegated greater resources to its whistleblower protection program, including hiring several new investigators to conduct whistleblower investigations. So that is definitely a part of this as well. I mean, the complaints that are filed are the complaints that are filed, but we're certainly seeing more response from the agency with these additional resources and this additional personnel. And I think getting more feedback and response from the agencies as the additional resources allow them to sort of dig into these investigations more and really sort of continue to sort of dig in and try to get more information. So I think that that's definitely a big part of the reason why this topic is so important now and why we wanted to make sure that we covered it in quite a bit of detail.
Can we talk a little bit about what laws are implicated when a whistleblower complaint is lodged against an organization?
Sure, I can jump in on that one. You know what, the most employers who are somewhat familiar with this will probably think of the predominant law, which is the OSHA Act, and from a legal perspective, it's Section 11C of the OSHA Act, and that basically, says that you cannot retaliate. And what retaliate means is really, discharge, discriminate, basically take any adverse employment action against someone who makes some sort of safety related complaint. And we'll get into the details about what does it actually mean to make a complaint, and what if you just voice your concerns to a coworker and things of that nature. But that is the predominant OSHA related aspect, although there are other similar rules in the OSHA context. For example, I defended a company about a year or two ago because an employee had made a complaint under the FSMA, the Food Safety and Modernization Act, that they complained about the company's food not being as safe as it should be, and then we had to defend that case. So that's kind of all of the whistleblower rules under the OSHA Act are similar. But then back to my experience as an employment lawyer, there are almost every other statute you can think of has retaliation components. And the way I like to explain it to my clients is it's almost like if you're watching a sporting event. And often if someone pushes someone, you don't see that push, you then see the push back, the retaliatory push. And then that second person is the one who gets a flag or gets a technical or whatever the case may be. And that's often what happens in the employment law context is an employer may take some sort of action that may be lawful, may not be lawful. We're not going to get into that. And then an employee may complain about that action. Let's just say in the pandemic context, like Lindsay was saying, we've seen so many of these cases in the pandemic context, that a company has a vaccine mandate, and then an employee, asks to be accommodated and not to have to take the vaccine because of a medical issue or because of a religious issue. And then we end up denying the accommodation, and then this employee doesn't have the vaccine, and then we end up terminating the employee. The employee will then commence a lawsuit for the employer retaliating against them because they did something lawful. They asked for a request under the Americans with Disabilities Act. They asked for a religious accommodation request under Title VII of the Civil Rights Act. Similarly, if you apply for leave under the FMLA, Family Medical Leave Act, and that leave, you end up firing someone later, even if it's not related to the leave, that employee can argue that you fired them for retaliation for them either asking or taking FMLA Leave Act. So I just want to make sure from my perspective here as the employment lawyer that all of the employers on this call are aware of the potential concerns and tricky situations involved with potentially we might not think of it as retaliating against someone, but potentially taking an adverse action after an employee has expressed some sort of request or some sort of right that that they believe they are protected from. And just finally, as I said, it basically every area of employment law has a similar anti-retaliation provision, whether it's the ADA, the DEA, which is age discrimination, whether it's race discrimination, whether it's religious discrimination. There's very few laws that I can think of. Even the Wage Payment Act also has anti-retaliation. So this just comes up in more contexts than employers often realize. Right.
So that sounds like it's very nuanced and can be very kind of complex for an organization. So if a whistleblower complaint is filed, what should an employer do?
I'll take that one. So I think the first thing that an employer can do is have a system in place for dealing with complaints when they come in. Employers come in all shapes and sizes. You may have outlying offices. The employee may file a complaint about a supervisor, and the only information that is provided to the investigating entity is that supervisor's name and address. So the complaint comes in, not to HR, not to legal, not to safety and health, but to the supervisor. And the supervisor has no idea what to do with it. So what you really need to do for your organization is figure out what you're going to put in place and how you're going to notify everybody what to do when you get a complaint. Now, once you get that complaint, you need to be prepared to deal with it. So you need to get a team put together. Typically, it would have managers, HR, legal, and particularly if it's an OSHA complaint, then you would want to have health and safety all on that team to be able to deal with the complaint. But you need to do it fast. So if you have a team in place, if you've got a system in place, it is so much easier to take the next steps. And during the webinar, we're going to be talking about the kind of information you collect, whether or not to do interviews. Do you need this document? Do you need that document? Do you need to do comparisons? There's all kinds of things that we're going to be talking about there. But the very first step is to anticipate that you may have a claim and have a system in place so that you can deal with it.
Great, thanks. And Victoria, you kind of touched on it a little bit, but what are the best practices to avoid having a whistleblower complaint filed against your organization?
I'll jump in on this one, and then certainly anyone from my team definitely feel free to give your input as well. But I think the sort of four major areas that we intend to cover during the webinar and talk about in more detail is first and foremost, and this goes back to what Victoria was saying, is to have a policy and practice in place, to have an established policy for how employees can make complaints internally, so that if there are concerns among employees, they are bringing those to the employer first, who can then investigate and address it in any way that is determined appropriate, as opposed to going to one of the agencies, as opposed to going to OSHA or the EEOC. So that's sort of the first step, is to have a policy in place and a practice for employees being able to raise those concerns and to respond to those concerns. And then the next step is to go along with the policy, you want to have training. So ensuring that employees know what the policy is, what the process is for filing any sort of complaint or bringing up any concern, and then what the employer will do with it from there. And then you also want to make sure that you have practices in place to be documenting both sort of the preventative steps, leading up to an adverse employment action. If an employee is having performance issues, that you are documenting those performance issues. If other discipline is issued, that you're documenting that discipline. So when, the ultimate action is taken, let's say termination, for instance, there's documentation to support that, because that will be important from the employer's perspective for its own uses, but also if a complaint is ultimately filed, to have that documentation in place. And then if the employer does have the opportunity to investigate, because let's say the concern is raised, at least initially internally, documenting that investigation and making sure that that is maintained as well to support any decision that's ultimately made. And then finally, and extremely importantly from our perspective, is employers need to be consistent in how they implement their disciplinary system and how they implement adverse employment actions, because that's going to be one of the first areas that the agencies are looking at to see, when this occurred in the past, was another employee treated differently? An employee who didn't make a safety complaint was, given another chance, or an employee who was not in that protected category was given the ability to fix their performance issues. So it's really important that employers are consistent in how they implement their policies and procedures and their discipline, and making sure, again, going back to that documentation, that is evident from the documentation as well.
Yeah, that's great. Great advice. I was going to say, we talk a lot about psychological safety and making sure people feel comfortable within their own organizations to raise those concerns and those issues. And maybe you'll dig into this a little bit more in the webinar on the 21st. But do you need to have very specific escalation guidelines in place, or is an employer able to kind of provide that outlet for complaints and then determine, where they need to, how far they need to go as far as dealing with them internally or reporting them externally?
I think you could have both the informal process and a formal process. A lot of times policies will say that you can start informally with whoever you think is appropriate. And then if you're not finding the resolution you're looking for, that there be a more formal process inside the agency. And again, by having that more formal process, that second outlet, it's less likely that they will then take another step outside the agency to complain. But if they do take that step, you've got all the documentation from the formal process. So I think you can do both.
Right.
And I'll just jump in and say, that's why we also typically, recommend all of our clients, something relatively basic, but having an employee handbook, and not all employers have that. So when an employee does have an issue, that they can go and consult the employee handbook that should have some sort of process that they can file for making complaints, safety related or otherwise.
Right. Yeah, just imagining that different size organizations in different industries probably have different level of sophistication and capabilities, but as long as there's a formal policy procedure in place, and that they deal with it quickly, like Victoria said earlier, that that you're on the right track.
Yep.
Yeah, great. Well, thank you guys so much for joining today. Really appreciate the opportunity to meet and discuss this topic and share it with our audience. And again, definitely encourage them to register for the upcoming webinar on March 21st and really dive into this topic. And we'll also include your contact information so that if people have any further questions, they know where to reach out. But again, what's the best way for people if they're dealing with this or they want to prevent this? What's the best way to get in touch with you guys?
I think
they can always send us an email or give us a call. I don't know if you have it, but we could provide you with, both our phone number and email address. And at least for me, either one is fine. I'm checking both of them all day, every day.
All right.
We also have a website that we keep up to date. So there's contact information there. And we also on that website have access to blog posts and webinars. So we have some resources out there too that can be sort of a good starting point, but certainly are readily available to answer specific questions and talk through specific issues. Great, thanks so much. And like I say, we'll include as many of those links as we can below in the description so people can click and connect. But thanks again so much for joining. Thank you.
Thank you.
Thanks.